Hello, I'm Professor Claire Germain from the University of Florida College of Law. And today we're going to talk about legal traditions, the common law and the civil law. You may have heard that the United States is called a common law country. Now, what does this mean in this today's world? As you can see from this wonderful map from the University of Ottawa, it's color-coded. So you can see, for instance, that the common law countries, it started in England, and then it was exported to North America, to United States, Canada, and then to Australia, New Zealand, parts of Asia, India, parts of Africa. Basically, the common law tradition is used in the English-speaking world. Now, there is another tradition, the civil law tradition, which is color-coded in red. Civil law started in Europe, in continental Europe, and then was spread out to Asia, part of Africa, usually corresponding to the colonial powers, and then to Central and Latin America. The common law and civil law traditions are not the only traditions. You also have some customary law, legal traditions, some religious traditions, like Muslim law, some mixed system which have inherited parts of the civil law, part of the common law, and some other legal traditions. But the common law and the civil law traditions are the ones that we're going to focus on today. So first, the civil law tradition, because it's the oldest tradition. For that, to explain it, we have to go back to Roman times, to Roman law. And you can see here an image of Emperor Justinian, who ruled over the Byzantine Empire. And in 533, or thereabout, in the 6th century, he commissioned a codification of the principles of Roman law, which was called the Justinian Code. What happened then is the code, it was in the 6th century, the document was kind of lost over the next several centuries. But then came the beginning of the Middle Ages. And toward the end of the 11th century and in the 12th century and 13th century, the Roman law text was rediscovered by scholars in the medieval universities. First in Bologna, Italy, then in Paris, in France, as you can see on this nice picture. So in civil law countries, the law was developed as a scholarly activity by professors. And even today, if you go to a French law school, to an Italian law school, to a Spanish law school, the teaching methods will resemble what was happening in the Middle Ages. Lectures, and students learn the law by reading treatises. Let's skip over a few centuries, and then in the 19th century, at the time of the nation states, some countries decided to codify their laws. So you saw the French Civil Code in 1802, the German Civil Code in 1900. So this codification is also a symbol, a characteristic of the civil law tradition. Now let's turn to the common law tradition. It's based on English law, and the law was developed not on the basis of exploring treatises, but on a case-by-case basis. And we have to go back all the way to 1066 and the famous Battle of Hastings, which is represented in the Normandy, the Norman Bayeux tapestry. What happened then is William the Conqueror, who was the Duke of Normandy, invaded England, and he imported his lords a strong central administration and the beginning of the royal courts of England. Then one of his descendants, Henry II Plantagenet, decided to install permanent royal courts in London. And it became the lawyers, the young law students, were trained in law not in the medieval universities, but directly at the courts and at the inns of court. And if you want to know why they were called inns, it's because the students lived there. So at common law, law was born out of procedure, out of the court system, not in books. And students today, they learn the law by reading case books in American law schools and by studying precedents. So I talked about law as tradition. Now I would like to talk for a minute about law as language. If you watch TV shows such as Miami Vice or other TV or movies, do you know that many of the words that you hear come from medieval law French or Norman French? Let me give you some examples. Trespass, voir dire, grand jury, petit jury, plaintiff. Why is there like a combination, breaking and entering, will and testament? It all comes from Old French. Now, today there is a convergence between the civil law and the common law traditions because of different factors, including the emergence of supranational legal norms and the blurring of civil and common law concepts as to the results achieved. So some people talk instead of a Western legal system or a Western legal tradition. There are still significant differences in the mentalities of the lawyers, the legal reasoning, and legal education. Now, this was just a short introduction, and I've asked you some questions about why these words, breaking and entering, and so on. So if you want to know more, I invite you to listen to my next lecture, which will be on legal traditions, the common law, and the civil law. So see you next time.